Hi, good afternoon.
How you doing?
Welcome to the Office of Tax Appeals, or OTA. My name is Stephen Kim, and I am the lead administrative law judge, or ALJ, for this oral hearing, the appeal of Dolivek. Today's hearing will be live streamed on YouTube. We have a stenographer, Lynn Alonzo, present and reporting this hearing verbatim. To ensure that we have an accurate record, I ask that each person speaks clearly, one at a time, and avoid speaking over one another. If needed, Ms. Alonso or any panel member or I will interject to ensure we have a proper transcription. After the hearing, Ms. Alonso will produce the official hearing transcript, and that will be available on OTA's website. OTA is not a court. We are an independent and impartial appeals body staffed by subject matter experts. We are independent of any tax agency, including the California Department of Tax and Fee Administration. While OTA is not a court, we must nevertheless follow certain guidelines to conduct an orderly hearing and to ensure that we establish a proper record on which the opinion will be based. Each party will have the opportunity to be heard, so please wait for your turn to make your presentation. Keeping the hearing on track and creating a clean and efficient hearing record is part of my role as the lead ALJ. So I may interrupt our hearing if we get out of order or become counterproductive. Before we go on the record, are there any questions about anything I said or about the hearing?
No, Your Honor.
No, thank you.
Great, thank you. Judge Ralston, Judge Stanley, are you ready to proceed? Great. Okay, so now we are going on the record. This is the appeal of B. Dolivek, OTA case number 231114784. The date is May 21st, 2025, and the time is 1:06 p.m. This hearing is being held electronically with the agreement of both parties. I am Judge Stephen Kim. I will be the lead ALJ for purposes of conducting this hearing. My co-panelists, Judge Teresa Stanley and Judge Natasha Ralston, and I are equal participants in deliberating and determining the outcome of this appeal. Parties, I just want to start with a quick introduction. Can you please state your name and who you represent and your title, starting with respondent, CDTFA?
Jennifer Berry, attorney with the Department of Tax and Fee Administration. Attorney, sorry.
Jarrett Noble, attorney with the department as well. Thank you.
Jason Parker, Chief of Headquarters Operations Bureau with CDTFA.
Thank you. And for appellant? Mr. Dolivek, can you just state your name?
Yeah, Brian Dolivek.
As stated in my minutes and orders, the issues to be decided in this appeal are whether any adjustment is warranted to the measure of unreported taxable sales, whether any additional relief from tax is warranted due to reasonable reliance on written advice from CDTFA, and whether any additional interest relief is warranted. Mr. Dolivek, do you agree that those are the issues in this case?
That is correct. I had some written advice that was misleading in my opinion, and that's what I would like to go over today. And also did some research on my own as far as what's taxable and not taxable when I spoke with individual at the Tax Opinion Experts department up in Sacramento.
Okay. And respondent, are these the issues to your understanding?
Yes, those are the issues as we understand them.
Great, thank you. Appellant submitted Exhibit 1, a notice of redetermination, and some other documents that are already included in CDTFA's exhibits. CDTFA did not object to the admissibility of this exhibit, so Exhibit 1 is now admitted into evidence. Also, we didn't discuss at the Brian conference, but Mr. Dolivek submitted 4 invoices with his additional briefing on April 29th, 2024. Does CDTFA have any objections regarding the admissibility of these documents?
No objections.
Great, then those invoices will be admitted as Exhibit 2. CDTFA submitted Exhibits A through E. Appellant did not object to the admissibility of these exhibits, so Exhibits A through E are now admitted into evidence. Mr. Dolivek, you indicated during the pre-conference that you intend to testify as a witness, and is that still the case?
That is correct, Your Honor.
Okay, and CDTFA did not raise any objections. Before we begin your presentation, Mr. Dolivek, I need to place you under oath so that we can consider your statements as testimony, and you will remain under oath until the close of this hearing.
Thank you.
So if you could please raise your right hand. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
You're welcome.
Okay, Mr. Dolivek, you will have 15 minutes for your presentation, and you may begin when you're ready.
Okay, so back in 2008, we received a letter from, at that time, it was the Board of Equalization, and I'm just going to read this, and I believe you have copies of this here, stating that we needed to get a seller's permit for our type of business on there. So this letter was generated on our company's behalf that was sent over to, at that time, the California Board of Equalization, and I'm just going to read through that, and then I'll read back the response letter that we received, and then I'll go into some further details on other investigation stuff that I found out through the opinions experts up in Sacramento. So the letter that we submitted was Beverly's Bartending Service is a full service staffing agency. When clients are planning a party, they call Beverly's Bartending Service for bartenders or servers. We charge an hourly fee for each bartender or server we send to each event. At Beverly's Bartending Service, we offer additional services, which is a procurement service. Procurement is when a client does not know what a bar should consist of. For a small fee, we arrange for a liquor store to deliver an order of all bar supplies needed for the event. And then I just give examples on there: liquor, beer, wine, napkins, and so on. The liquor store then bills Beverly's Bartending Service. Then we pass the charge on to our client's invoice. When Beverly's Bartending Service books a party that is using the procurement service, we put on their invoice an estimated charge for the purpose to determine a deposit to our clients. Our customers are only billed for what supplies they use and whatever is left over that is open. The liquor store picks up any of the products that's not that's not opened at each event, and then bills Beverly's Bartending Service for that. Clients do not use our procurement service supply of their own goods for all of our staff to use. All of our bartenders and servers are hired as contract labor. My question to the board, Equalization: do we need a seller's permit for labor services? We do not sell any tangible goods. And at that time, in 2008, they were contract labor, but then laws changed, so all our staff are now considered employees, and that's been for several years on there. So the response I received from Miss Virginia Galing was: an exempt for sale for resale takes place when the liquor and supplies pass title from supplier to you. A retail sale takes place when you bill your customers for the same liquor and supplies to your client since the title and possession was transferred. This is the case regardless of the fact that the amount you're charging your client is the same as your cost. Contrary to your letter, we consider your seller a seller of tangible personal property. The fact that you're making sales of tangible personal property in California requires you to obtain a seller's permit. Further, if you have a client to whom you're providing bartending services only without providing any tangible personal property, your charges for the services are exempt. If you have a client to whom you're selling liquor and supplies along with bartending services, all charges, including those for the liquor and supplies as well as bartending, are taxable. You may purchase liquor through a resale certificate. That's separate because at that time we did not have a liquor license to do all that. So we had to go through a store that had the proper licensing. So in the letter here of written advice, I do mention in the letter that we wrote that we provide bartending and serving staff. And then the response is only addressing the bartender, stating that basically if we were providing any tangible personal property, which would be supplies from the liquor store at the time, that would become transfer personal tangible property, and that would be taxable. So when I had the original audit, Sean was my auditor. He exempted tax from any of the invoices that did not have personal tangible property on there, but he continued to say that owed tax for any invoices that were just servers based or if they had servers on the invoice. And what I find a little bit misleading in the response from Ms. Galing is that she never mentioned the serving staff. So the way we took it as it was only addressed with the bartenders because of bar supplies. And I feel that it's a little misleading because it should have been addressed that if you're providing bar supplies, all bartenders and service and the entire invoice would be taxable. So I do feel that was a little bit misleading because we do mention that we have servers as well, which is obviously bussing dishes, serving buffets, doing things of that sort that a server would do at a private event or a client's home on there. And that was never addressed in the letter that was a response from Ms. Galing. It was only about bartending services. So we took it as any invoices that had servers on it, if it just had servers by itself or if it had servers and bartenders, that was exempt from tax. It was never clarified in the response letter. So we took it as just bartending. So when Sean did the audit, he did charge tax to me saying it was delinquent tax or whatever you guys classify that as, that was all taxable items and that would have to be paid. And that's a big chunk of the balance that they're saying that I owe was any invoices that had servers on it. And again, it was not addressed in response letter. So we didn't know that that was taxable because there was no tangible personal property tied into servers because we were not technically, when I say we're not a catering company, meaning that we don't provide, cook, or furnish food for our customers. It's just literally labor services of staffing on there. So I do feel like that written advice was misleading. And in the long end, we were, punished by being fined and penalized with interest and so on and penalties for any of the invoices that had servers on it. That was not taxed. And again, it wasn't specified in this letter. So I felt that was very misleading. And then upon some research as this went through the audit process, I contacted a gentleman named Eric at the Tax Opinions Experts Department up in Sacramento, and I explained my situation, explained I was going through an audit, and he pointed out its annotation 550.0838, 1603 subdivision I-1. And that states in there that it's under caterers, and it states definition. The term caterer as used in this regulation means a person engaged in the business of serving meals, food, or drinks on the premises of a customer or on the premises supplied by the customer, meaning I assume like a rental facility, including, it does say including premise leased by customer from a person other than the caterer, but does not include employees hired by the customer by the hour or the day. And what Eric explained to me is, since we're a service company and we charge our clients by the hour, that we were exempt from tax unless we had personal tangible property on the invoice, as Mrs. Galing later states. But what he was explaining to me, if we are sending out just servers on an invoice or servers with bartenders, there's with no personal tangible property, that would be exempt from tax. And that's under, again, the definition term in cater is used under the 1603 subdivision I-1. And I believe I submitted a copy of that as well. If not, obviously that could be found on the website for the CDTFA on there. And I did call around to get quotes of other companies that do the exact same thing that we, the services that we provide. And if you notice on those quotes, not any of these other service companies or staffing companies are putting tax on the bills. I did notify Sean that there's many companies out there that provide the same service that do not charge tax. And his comment was, well, we can't target everybody, or something in that terms. I can't recall. That was many years ago on there. And, to this day, if you call around, all these companies do the same thing. There's a company in LA that's been around for many, many years, which is a very huge company. And to this day, they still don't charge tax on any of their services that they offer, as far as bartending service and staffing service for any servers or busboys, what are they offering that do not have tangible personal property on the invoices. And again, comparing to the companies doesn't mean if it's wrong or right if they're doing it. The point is that I feel like I'm being targeted because this started in 2018. It is now 2025, and all these companies are still doing services without paying tax. And I believe that they're probably pulling up under that definition 1603 subdivision I-1, because again, they are charging on an hourly basis just like we do. And I think that's how they're probably getting away with it. I'm not quite sure. I'm just using my own knowledge and research that I've done of my own investigation on there. But I feel like I'm being targeted because any of these companies you call, there's literally hundreds on the internet nowadays all over, and none of them are charging tax on service-based type services, same services that we provide. The only difference is we do provide a procurement service. And again, I did put tax on all those invoices, and Sean, my auditor, did see all that. So I feel like the audit was not accurate and fair due to the written advice not specializing or mentioning the server aspect of it. So a little misleading. And then also when it comes down to the subdivision I-1 under 1603 stating if customer is hiring employees by the hour a day, that it's basically exempt from tax.
Okay. Do you have anything else to add, Mr. Dolivek?
No, that's pretty much it right there. Just wanted to state the facts of the response letter and from the annotation 550.0838, 1603 subdivision I-1 on there. So that would be my two things, stating that the written advice I feel was misleading. And again, the since we're a staffing service, again, technically we're not a caterer. I know California classifies us as a caterer because we're touching food and drinks. But technically, we're not providing food and meals and charging for that kind of services. It's literally labor staffing services. And again, we do charge our clients by the hour.
Okay, and regarding the issue of whether any additional interest relief is warranted, did you have anything specific to that, or are you just arguing that if the tax is not if you're not liable for the tax, you're not liable for the interest as well?
Yeah, no, I would argue that the tax and all the, this was delayed many, obviously, years due to COVID, and then the delay of getting into this point to appeal this at your office obviously inquired a lot of interest and fees. So I definitely would like to have all that in consideration of alleviating all this extra tax that I'm being, in your court with you guys here today. Because again, I feel like I was misled from the written advice letter, and then also when it comes down to the servers where he's charged me tax on several invoices, and they believe audited 3 quarters, if I'm not mistaken, but I guess the process is that they go back 3 years, so they do a percentage of can't recall what he called it, but it's a percentage of I honestly can't recall. They're over a 3-year period, so that's how he came up with the tax saying that I owed on there. So yes, I'm looking for relief of the tax bill that I'm being sent from the CDTFA.
Okay, thank you.
You're welcome.
It's my co-panelists, Judge Stanley or Judge Ralston. Did you have any questions for Mr. Dolivek at this time?
This is Judge Stanley speaking. Thank you for your presentation. I don't have any questions at this time.
This is Judge Ralston. No questions at this time.
And CDTFA, did you have any questions for Mr. Dolivek as a witness?
No questions at this time.
Okay. Then let's move on to CDTFA's presentation. Respondent is not presenting any witnesses and will only be arguing the appeal. You requested 20 minutes for your presentation, and you may begin when you're ready.
Liability in this case stems from an audit of appellant's business for the period fourth quarter 2014 through third quarter 2017. During the liability period, appellant operated a full-service party planning, staffing, and equipment rental company as a sole proprietor, doing business as Beverly's in Thousand Oak, California. The department issued a notice of determination for the liability period in the amount of $10,493 in tax plus applicable interest on January 10th, 2022. That consisted of unreported taxable sales measuring approximately $113,000. Upon audit, appellant provided incomplete records, including, among others, sales invoices for the first quarter 2016 and third quarter 2017. These invoices are available within Exhibit C. Since appellant's records were incomplete, the department was required to utilize an indirect audit approach by projecting errors from the sample period consisting of first quarter 2016 and third quarter 2017 to compute appellant's audited taxable sales for the liability period. Accordingly, the department compared appellant's recorded sales to those quarters to appellant's reported taxable sales for the same periods and found error rates of 195.57% for first quarter 2016 and 209.36% for third quarter 2017. These findings are detailed on Schedule 12A1 of the audit work papers, which are available within Exhibit C. Additionally, as will be discussed in more detail shortly, during the audit, the department determined that appellant treated bartending and waitstaff services where he did not provide tangible personal property as non-taxable transactions, even though those transactions are taxable. However, the department also determined that appellant reasonably relied on the department's erroneous written advice during the liability period and was entitled to relief pursuant to Revenue and Taxation Code Section 6596. Accordingly, the department determined that 34.49% of appellant's taxable sales for first quarter 2016 and 26.63% of appellant's taxable sales for third quarter 2017 were services for which appellant was entitled to relief. The calculations for this relief may be found on Schedules 12A3, 12A4, and 12A5 of the audit work papers, which are available within Exhibit C. The department then applied the percentage of error it calculated for first quarter 2016 to all periods except for third quarter 2017, and it applied the percentage of error it calculated for third quarter 2017 only to that quarter to compute audited taxable sales of $347,989 for the liability period. The department then allowed the Revenue and Taxation Code Section 6596 relief in the form of an offset to the audited taxable sales by reducing the audited taxable sales it calculated by 34.49% for all periods except for third quarter 2017 and by 26.63% for third quarter 2017. This reduced the audited taxable sales to $230,569. Finally, the department subtracted appellant's reported taxable sales for the liability period from the audited taxable sales to determine unreported taxable sales of approximately $113,000. Revenue and Taxation Code Section 6051 imposes sales tax on a retailer's sales in the state of tangible personal property measured by the retailer's gross receipts, unless the sale is specifically exempt from taxation by statute. Under Revenue and Taxation Code Section 6091, all of a retailer's gross receipts are presumed subject to tax unless the retailer can prove otherwise. Where the department is not satisfied with the accuracy of the tax returns filed, Revenue and Taxation Code Section 6481 provides that the department may base its determination of the tax upon facts contained in the return or upon any information that comes within its possession. Further, under Revenue and Taxation Code Section 6481, when it is determined that a taxpayer's records are insufficient or are proven unreliable, it is appropriate for the department to compute and estimate the taxpayer's liability by alternative means. As set forth in Regulation 30219, where the department's determination is reasonable, the burden of proof is upon appellant to prove all issues of fact by a preponderance of the evidence. Appellant must establish by documentation or other evidence that the circumstances he asserts are more likely than not correct. Appellant has disputed two specific invoices that were included within the sample period. First, appellant disputed the department's determination that appellant's sale of a photo booth package in the amount of $695 during the first quarter of 2016, as reflected on invoice number 5154, is taxable. Revenue and Taxation Code Section 6012 establishes that mandatory services are regarded as part of the sale of tangible personal property, and therefore those services are taxable. Based on information on that invoice and that appellant has provided to the department, the photo booth package included 2 mandatory attendants as well as tangible personal property in the form of physical prints of photos and a photo CD. Thus, the entire charge for the photo booth, including the cost of the mandatory attendance, are subject to tax. Appellant has not provided any evidence to establish that adjustments are warranted to this determination, and therefore no adjustments are warranted. Appellant also asserts that $2,184 in sales of food, equipment, and supplies that are reflected on invoice number 5442, which occurred during third quarter 2017, are not taxable because he paid tax on those purchases. Under Regulation 1603, Subdivision I, Paragraph 3, tax applies to the entire charge made by caterers for serving meals, food, and drink, inclusive of charges for food, the use of dishes, silverware, glasses, chairs, tables, and other supplies used in connection with serving meals, and for the labor of serving the meals, whether performed by the caterer's employees, or subcontractors. Since invoice number 5442 was comprised of food, supplies, and equipment used in connection with serving meals in appellant's capacity as a caterer, it was a taxable sale. Therefore, appellant is liable for tax on this sale. We further note that even if appellant was correct in his argument that he has not provided documentary evidence to substantiate his payment of tax upon his purchases for these items, nor did he follow the procedures required to claim a credit for tax paid purchases resold pursuant to Regulation 1701. Therefore, no adjustments are warranted based on this contention. As mentioned earlier, in its examination of appellant's invoices for first quarter 2016 and third quarter 2017, the department removed sales in the audit where appellant provided bartending services, but the tangible personal property such as alcohol was provided by third parties due to appellant's reliance on erroneous written advice provided by the department. As set forth in Regulation 1603, Subdivision I, Paragraph 3, Subparagraph A, these transactions are taxable even in cases where tangible personal property is not sold as part of the transaction. During the audit, appellant provided the department a copy of a letter issued by the department dated April 18th, 2008. A copy of this letter is available within Exhibit C. Specifically, the letter stated that the transactions that involved the provision of bartending services only without providing tangible personal property were exempt from taxation. The department determined that this letter constituted erroneous written advice pursuant to Revenue and Taxation Code Section 6596, which appellant had reasonably relied upon during the liability period. Accordingly, the department determined that appellant was entitled to relief for those transactions in which appellant only provided bartending staff without also providing tangible personal property. The department also extended the relief to include transactions in which appellant only provided wait staff without also providing tangible personal property. Pursuant to this determination, the department removed invoices from the sample period where appellant only provided bartending or wait staff services. As noted earlier, these calculations are shown on Schedules 12A3, 12A4, and 12A5 of the audit work papers available within Exhibit C. Specifically, for first quarter 2016, the transactions for which relief was granted is shown on Schedule 12A4 in column Y, and for third quarter 2017 on Schedule 12A5, column AC, capital AC. Also, as also discussed earlier, the department applied relief to the remainder of the liability period aside from third quarter 2017 in the form of an offset to the audited taxable sales based on the offset it determined for the first quarter 2016 of 34.49%. And for third quarter 2017, the department applied the offset of 26.63% that it calculated on an actual basis. Since appellant did not provide complete records, the department's utilization of a sample test period was reasonable and rational. And the department has already provided appellant relief for the invoices on which appellant provided bartending or waitstaff services without the sale of tangible personal property. Moreover, the department applied the most favorable error rate and relief to 11 of the 12 quarters of the liability period to estimate appellant's unreported taxable sales. Therefore, appellant bears the burden of proof to show that adjustments are warranted here. Though appellant asserts that the department has not accounted for some non-taxable invoices, appellant has not identified any invoice or invoices within the sample period that he believes should have been but was not included within the relief provided. Therefore, no further reductions are warranted based on appellant's prior reliance on erroneous written advice. To the extent that appellant asserts that some of his charges for bartending and waitstaff services are not subject to tax to regulation pursuant to regulation 1603 subdivision I, paragraph 1, as explained by annotation 550.0838, we first note that the term caterer as is defined as relevant here to mean a person engaged in the business of serving meals, food, or drinks on the premises of or supplied by the customer, but does not include employees hired by the customer by the hour or day. Annotation 550.0838 makes clear that the reference to hourly employees in regulation 1603 is to hourly employees hired by the customer and is not a reference to the caterer's hourly or daily employees. It is undisputed that appellant is a caterer and that he provides bartending and waitstaff services as part of his services. Though the bartending and waitstaff services that appellant, though the bartending and waitstaff that appellant employs may be hired by the day or hour, it is appellant, not his customers, that hires those employees to work at his customers' events. Therefore, the exclusion for employees hired by the customer by the hour or day does not apply to appellant, and the remaining provisions relating to the application of tax in the case of a caterer apply to appellant's business. As previously mentioned, under Regulation 1603, tax applies to the entire charge made by a caterer, and as we discussed in detail, appellant has already been provided relief for invoices within the sample period that include only bartending or waitstaff services. Thus, tax applies to the remaining invoices. Here again, appellant has not identified any particular invoice or invoices within the sample period for which adjustments are warranted, and he has not therefore met his burden of proof. Finally, appellant has requested interest relief for the period fourth quarter 2014 through third quarter 2017, contending that there were unreasonable delays by department employees in completing the audit. A copy of this request may be found on page 30 of Exhibit A. Though appellant did not specify any other dates, the department presumed in appellant's favor that he was also requesting interest relief for the periods during which the audit was ongoing until the issuance of the notice of determination. The department granted relief of interest for the period March 1, 2018 through September 30th, 2018, and the period July 1, 2020 through December 31, 2021. Additionally, the department automatically granted relief of interest for the period March 1, 2020 through June 30th, 2020, consistent with Governor Newsom's executive orders in response to the COVID-19 pandemic. The department denied appellant's request for relief for the remaining periods. Revenue and Taxation Code Section 6482 requires a deficiency determination to bear interest from the last day of the month following the quarterly period for which the amount or any portion thereof should have been remitted until the date of payment. The imposition of interest is mandatory, and Revenue and Taxation Code Section 6593.5 provides for relief of interest only under very narrow circumstances, including, among others, an unreasonable error or delay by a department employee in his or her official capacity. Under Revenue and Taxation Code Section 6593.5, when a taxpayer requests interest relief due to an unreasonable error or delay by a department employee, relief is appropriate only when no significant aspect of the error or delay can be attributed to any act or failure to act by the taxpayer. With regard to the liability period of first quarter 2014 through third quarter 2017, Revenue and Taxation Code Section 6482 requires the amount of the deficiency determination to bear interest from the last day of the month following the quarterly period for which the amount or any portion thereof should have been remitted until the date of payment. Thus, appellant is not entitled to relief for the accrual of interest during the liability period itself. Additionally, during the remaining periods, the department's records show that department employees diligently worked on the audit and made frequent contact with appellant. During this period, any delays were the result of appellant rescheduling or not attending appointments with department staff and extensions of time requested by appellant to provide supporting documentation. Thus, a significant aspect of any delay during these periods can be attributed to an act or failure to act by the taxpayer. Accordingly, appellant is not entitled to any additional relief beyond the periods already granted by the department. Thank you.
Thank you, Ms. Berry. So I just wanted to clarify, the department has already granted relief for invoices that showed not only for invoices without any sale of tangible personal property, but not only for just bartending services, but also wait staff services as well.
Yes,
Yeah.
that's
Yeah.
correct.
And just to be clear, it's not necessarily we have granted relief for transfers of TPP where they didn't provide it. We just took what they provided and granted relief on bartender charges and wait staff charges. We still maintain that any transfer of TPP where appellant had possession of it and then created an event is taxable, but it was removed from the audit.
Okay, and for those transactions, is the department making a distinction between wait staff and caterers?
No, we're not making a distinction. I think what the department did was suggest that they provided advice on bartenders and they extended that to wait staff during the audit period because the advice was similar.
Okay. I'm gonna ask my panel members if they have any questions for respondent, Judge Stanley.
This is Judge Stanley speaking. Just to follow up on the last question. So if we look at the first invoice attached to the decision, it's got bartenders, servers, and the photo booth and a scrapbook. So when you're saying that you gave relief for charges, that you would have given relief for just the bartender services and the server services, not for the TPP, is that correct?
Only where there was no TPP transferred. That invoice that you're referring to is the specific one regarding the photo booth that was objected to during the appeals process. The
Okay,
other
so
invoices, sorry, go ahead.
I was just gonna clarify. So the entire amount in this particular receipt would have been considered taxable.
Yes.
Okay.
The
That's all.
entirety of the invoices are also that were provided are available within Exhibit C. There's two files, one for each of those 2 quarters.
Okay, thank you.
Ms. Walton, did you have any questions for respondent, CBTFA?
No questions. Thank you.
I just want to clarify something with Mr. Dolivek. You didn't mention it in your presentation, but are you still arguing that those 2 invoices, invoice 5154, that's the one including the photo booth package, and invoice 5442, including some equipment and food supplies, are you still disputing those invoices as well?
What I'm disputing, the photo booth was from an outside company. So there's companies that we work with, and the client asked me if we can just put it all one bill, and which we did do on there. And at the time that was generated, the photo booth company assured me there's no tax on their services as a photo booth. And I did call down the tax opinions experts department on there, and they told me that was a gray area between photography services and photo booth. It wasn't really clear on there. So I am not disputing that was on the invoice on there. And again, that was not services that we provide. Yes, it was on my invoice just to be reimbursed myself and the client to pay the photo booth company that was subcontracted on there. And then far as the invoice relating to equipment that was purchased and food supplies, that was the client asked the day that we arrived if we can go pick up the food for her, and we just put it on our credit card. We did pay tax at the local grocery store, which was, I believe it was Albertsons, if I'm not mistaken. I can't recall the store. It's been so many years on there. And then far as equipment we purchased from Chef Toys, we did pay tax on that. And I believe I did submit some receipts to Sean. I can't recall what receipts were submitted on there back in whatever the date was, 2020 or 19. I believe that was prior to COVID when I was meeting with Sean on there. So I'm not disputing that those were on the invoices, but tax was definitely paid on any equipment that was purchased from Chef Toys, because we did not have a resale license for that kind of equipment. And when we went to the grocery store, obviously, we just purchased from a grocery store and reimbursed ourselves for that. So I'm not disputing those were on the invoice. Off that subject, though, and you may get to this in a moment, I am disputing that they're saying I got relief of tax for any wait staff and services, because Sean made it very clear to me he was not exempting tax for any of the wait staff. He said only the bartending service that did not have tangible personal property on there. So I remember
Just
that
stop
clearly.
you for a second, Mr. Dolivek. You did ask for some time to make a rebuttal or a final statement, so you have 5 minutes, and
Okay.
you can begin now.
Yeah, I'm sorry.
You can begin with your rebuttal.
Okay, gotcha. So taking those two invoices, one for the photo booth and one for the equipment that was purchased on there. Like I said, I'm not disputing that on there. Like I said, I know I paid tax on the equipment, like I stated just a moment ago. And from my understanding, photo booths were not taxable, at least at the time when that took place. I'm not sure if that changed. But again, back when Sean was auditing it, he did specifically say to me he was not relieving any liable tax for wait staff, because the letter did not state wait staff, only stated bartenders. So my question now is, if they're charging me all this tax for those two invoices, if they're saying I have to pay tax for the equipment and supplies that were purchased and the photo booth under, that seems like a high dollar amount of tax that I have to pay for two invoices on there. And again, I don't know how they do the percentage of error over the quarters for the 3 years. But again, I can't believe the tax would add it to that kind of liability just for those two invoices on there. And again, I don't have any record of them giving me credit for any tax liability for service. I just recall Sean said he's going by the letter, and the letter only stated bartending services.
Okay, thank you. CDTFP, did you have any questions for Mr. Dolivek?
No questions at this time. Thank you.
So Mr. Dolivek, you stated that there are additional invoices where you were not, or where you believe that there were only services and no tangible personal property sold. Do you have those invoices, or do you know which invoices they are?
I'm sure I can pull up. I'm sure the CDTFA has all those. I submitted all the invoices, and to go back to them saying I didn't have proper records, I submitted every invoice for the quarters I was being audited on for any events that we did or clients we work with. So far as whatever records I had, I did submit to them. So the comment of having insufficient records, I don't know what they consider sufficient, because I literally submitted every invoice stating exactly what the services were on there. And that's where they got their information from, was only from the invoices that I submitted, and they have all that in their possession at the time that we did the audit, and I believe they still have copies of all those invoices. And again, I'm just going from the auditor's word to me that the letter stated from the CD from at that time the state board legalization, it was only for bartending services, and he was not going to exempt tax for any of the wait staff services. And I recall that clear as daylight. And I'm sure I can go through all those invoices from back in that period, and we can probably run all the calculations to determine if he did or not. But I know he's clearly made it clear. He certainly made it clear that the letter stated only bartending services, and that's all he was going to address from that letter. And again, I can't see two invoices, if you're saying those are taxable for a photo booth that was subcontracted, and some supplies and purchases that were already paid. And again, I do believe I submitted a couple of the receipts. I can't recall 100%, but I believe I did submit some receipts to Sean. And again, the department should have those receipts if I did on there. But like I said, I'm 100% sure Sean said that to me, that he's not relieving any tax liability for any wait staff services. That was verbally to me. He told me that.
Okay, I believe that was during the audit. CDTFA, I believe they stated kind
We
of the
have a
opposite.
bit of a response. I would just say that pursuant to 6006 subdivision D, the furnishing, preparing, and serving of food or beverages for consideration is defined as a sale. So if the department previously advised appellant that bartending services where the customer provided TPP was not subject to tax, that was relieved because it was erroneous advice. And if the department took other invoices that involved the wait staff with the same similar circumstances and removed them, that was the benefit of taxpayer. Irrespective, if you are taking TPP from a customer involving food, beverages, and such, and transforming those to serve them at an event, they are subject to tax. The department has removed any bartending services that related to that. And to my knowledge from looking at the work papers, also wait staff involving events to that. They have not pointed out any other specific invoices involving those facts that warranted erroneous advice and relief pursuant to 6596. Therefore, there is no reason to recommend further reductions.
This is Jason Parker. Judge Kim, I just wanted to add on a couple things for some clarification. I just wanted to give you a line item in the audit on Exhibit C, the audit working papers. Schedule is 12A5. The line number reference is 17. The invoice number is 5424. What we scheduled in the audit was $840 for wait server staff. That's the only thing on the invoice. There's a column under column AC, qualifies for written advice. We adjusted $840. So we have adjusted wait staff when that's the only charge on the invoice, similar to what we did for bartending services. The other item, tax paid purchases resold. If you look at column AA on the same schedule, there's a column labeled allowable credit. The first one on the list is line 14. There was $176 under the disposable column, which is column T. We adjusted for that since they already paid tax on that amount already. And there's comments to that effect in the audit. And there's other examples like this as well. I just don't want to go through them all due to limited time.
Thank you.
Can I make a comment to that?
Sure.
Okay. So if they're saying they relieved all the tax for all the bartenders and servers that had no tangible personal property invoices, and they're claiming these two invoices with the photo booth and the one for supplies, equipment ordered and supplies, how did the tax bill get so high? Because all the other invoices, from my recollection, that had tangible personal property on their tax was paid to the department. So how do we get such a high tax bill based off the two invoices? And again, I knew they do percentage of error and they do their calculations to get it over a 3-year period. But if I was relieved tax on all those invoices that had wait staff on it, how is the tax liability so high? Because the department's not denying that I didn't pay tax on all the invoices that had tangible personal property on it. Obviously, tax was collected, tax was paid for those invoices. So I would like to see a breakdown of what I'm being charged, all this liability that they're saying I owe, if I've been relieved or granted, relief of tax from any wait staff server invoice. And again, verbally from the auditor, Sean said to me that the letter states for bartending services only, not wait staff services. And I'm not quite sure what graph they're looking at. I don't believe I have copies of those. And I don't understand exactly where they're coming up with all this tax. Because again, tax was paid on invoices that had tangible personal property.
Okay. Thank you.
You're welcome. Thank you.
I just to clarify on the invoice with the photo booth. Said you subcontracted that, so you hired the photo booth and you paid the photo booth?
So the photo booth company was the name of that company. Not sure if they're in business today. Is called Caneo Photo Booth. They were contracted for the event. The client wanted to know if all the services could just be on one bill. Again, I think it was maybe for tax purposes for them. And I said that's not a problem. And then we went ahead and billed them for that, and I paid the photo booth company. And again, when I spoke with the tax opinions experts regarding the photo booth, he did say that was like a gray area because photography is taxable, but there was no clear definition on photo booth. And to this date, this has nothing to do with our case. But every photo booth I've researched does not charge tax on their invoice. And again, that has nothing to do with this case. Doesn't mean they're right or they're wrong. But, and again, there was no definition answer from the tax opinion experts on the photo booth charges, if that's taxable or not. The only category that fell under was photography. And the photography meant more like a photographer showing up at a wedding or event from the explanation I got from that expert's opinion.
Okay, thank you.
You're welcome.
Judge Stanley or Judge Ralston, do you have any final questions?
This is Judge Stanley speaking. I do not.
This is Judge Ralston. No questions. Thank you.
Okay, thank you. All right. Okay, so this case will be submitted today on May 21st, 2025. The record is now closed. Thank you everyone for participating today.
Thank you.
The judges will meet to deliberate and decide your case, and we will issue a written opinion within 100 days of closing the records today. So today's hearing in the appeal of Dolivek is now concluded. This hearing is adjourned, and this concludes the hearing calendar for today. There are more hearings on the calendar for tomorrow, so hearings will resume tomorrow at 11 a.m. Okay, thank you.